welcome back to another U.S. immigration law video. Today, I will specifically be discussing a new policy update from U.S. Citizenship and Immigration Services, USCIS, around the I-130 petition. If you don't know what an I-130 petition is, the I-130 petition is what is filed for a foreign relative. And this is used if you're sponsoring your spouse, a child, a parent, a sibling to come to the United States. And this update by USCIS was August 1st, so it was just a few days ago. And the update reinforces, or I guess sets forth, a policy in what USCIS states is to safeguard the integrity of the family-based immigration system and enhancing its vetting procedures for petitioners and beneficiaries. And this new policy clarifies, and the second word I think is very important, reaffirms. So not all of this is new. They are just reaffirming policy that they've had before, and they are being more strict in their adjudication of I-130s. And a lot of people are fearful because of this update, and they were afraid that if they file an I-130, they're going to put themselves up for removal proceedings with all that's going on right now with the Trump administration and ICE and increased apprehensions and removal of foreign nationals from the United States. So the biggest part of this update I think that people are targeting and looking into is, there are two actually. One is interview requirements for family-based petitions. And we've already seen this. So this update is just reinforcing something we've been seeing since Trump took office, and that is the reinstatement of interviews for family-based petitions filing for adjustment of status in the United States. Interviews are, it says, while not all I-130 cases will require interviews, applicants should be prepared for an interview. And for marriage-based cases, we have seen USCIS go back to the pre-Biden rules where they were interviewing everybody who was filing a marriage-based case. Biden waived virtually every interview. I don't think we had a single case go to interview under the Biden administration. People were just being, I would say, rubber stamped approved as long as the petition was properly supported with evidence of the bona fide relationship. Well, that's gone away. Under Trump, we're going to interviews multiple times a month where it's a family-based case, and they've reinstated that in-person interview. So that's something to be prepared for. So adequately support your case with the bona fides of your relationship, but also be prepared. You will be going to an interview almost for sure under this administration. So reinstatement of that interview process for I-130 family-based petitions, specifically for a spouse of a U.S. citizen or a U.S. permanent resident for that matter. And also this policy talks about what is called a notice to appear. And this is the one I think is striking the most fear in individuals. And that is that if USCIS adjudicates that I-130 and they don't grant the status that you're asking for, in other words, they deny that I-130, and it leaves that foreign national spouse without status, USCIS could issue a notice to appear and put the beneficiary into removal proceedings. And this includes individuals with no prior immigration violations or criminal records or ineligible immigration histories. Specifically, I would say this applies to an individual, for example, that came in the United States. Maybe they came in legally on a visitor visa or on a work visa, and now they're filing for adjustment through marriage to a U.S. citizen. And during that process, they fall out of status, and now they are out of status. Well, they could be put into removal proceedings if the underlying request is denied. Now, this has always been the case. If you file with USCIS and your request is denied and it leaves you without status, you were removable from the United States. Now, the difference is the Biden administration wasn't pursuing these individuals. They weren't actively issuing notices to appear for individuals that fell into that situation. Now, the Trump administration is. They're saying that if that underlying status is not maintained and the benefit that you are requesting is denied, you will be put into removal proceedings. You will receive a notice to appear. So as long as you're doing the process legally, you're qualified for the benefit, your petition is adequately supported, it's a bona fide marriage, we haven't seen any issues in this regard. We have seen our clients get approved through their valid marriages, even individuals who have overstayed a visa, even individuals who might have fallen out of status. As long as that case is properly filed and supported with the bona fides of that relationship, we aren't seeing those individuals facing notices to appear or removal. The only individuals we're seeing that happen to are individuals who would fall into the category of an immigration violation or criminal violation, or maybe the marriage isn't bona fide, so that's denied, and that puts them at risk of removal from the United States. So although these policies aren't new, and this is what we've seen with a lot of Trump administration, they are handling the procedures differently than the past administration. Again, in the past, under Biden, you could have had a marriage-based interview. They were just waiving them all. In the past, under Biden, you could have received a notice to appear. They just weren't doing it. So the Trump administration is taking a much more aggressive stance on these cases where they are enforcing those in-person interviews, and they are issuing notices to appear, and you will be put into removal proceedings if the case warrants it. So if you are filing a marriage-based case or a family-based case based on that I-130 petition, be aware of a change in this administration's